The rights that the creditor has on debtors default. The most common form of default is when the debtor fails to pay. Another form is when the debtor files for bankruptcy. In this section, we're going to talk mostly about repossession. The judicial process is another remedy that a creditor has, but they have to go to court. They got to hire an attorney. They incur more expenses, and basically they have to sue the debtor, and in the end they get a judgment, right, which is a piece of paper that says you are legally obligated to pay the creditor. Creditors like repossession, where they just go in and they take the property. So let's talk about repossession. Repossession is when the creditor can take peacefully possession of the collateral without having to go to court. And peaceful means there's no trespassing, there's no breaking and entering, there's no assault. And there's probably another handful of rules, but really you can't go in and break into somebody's garage to take their car. No trespassing is a little gray area, because if the car is parked in the driveway right there, they actually can come and repossess the vehicle, but they certainly cannot assault or threaten people. Once the secured party repossesses the collateral, they can do a couple of things. They can retain the collateral, or they can resell it and apply the proceeds to the debt. If they decide they want to retain it, they have to give notice. They have to give notice to the debtor, and they have to give notice to other secured parties in that collateral, unless the collateral is a consumer good. Of course, the debtor can sign off their rights to it. So if that happens, no notice is required. But if not, we need to give notice to the debtor and other secured parties in that collateral. That isn't a consumer good. Once they receive notice, if either party objects within 20 days, the objection has to come within 20 days. If there's an objection, then the secured party who has possession of that collateral must sell it. If the secured party sells the collateral, they have to dispose of it in a commercially reasonable manner, which could be a public or a private sale. They must do it within a reasonable time. They have to do their sale in good faith, and they have to notify the debtor of the sale. If the collateral is a consumer good and our debtor has paid 60% or more, the secured party must sell the collateral within 90 days of taking possession, or they might become liable to the debtor if they don't. So how are the proceeds from the sale dispersed? Well, there is an order. Off the top are any reasonable expenses incurred by the secured party in repossessing, storing, and reselling the collateral. And once that's paid off, then the satisfaction of the debt owed to that secured party, then any other security interests beyond that in order of their perfected status, if there's more than one. And then in the end, if there's anything left over, it goes to the debtor. But rarely do we ever get that far. Rarely do we ever have enough money to satisfy the debt. So let's say that doesn't happen. Let's say that after reasonable expenses, there isn't enough to pay the debt, and there's $3,000 left over. At that point, the secured party can sue for the balance and obtain a judgment called a deficiency judgment after the fact. So I buy an all-terrain vehicle on a loan for $6,000. I default after paying $1,000, leaving a $5,000 balance. The ATV is repossessed and sold for $3,500, which leaves a $1,500 balance. The secured party can sue me in court to seek the rest of that balance. Any time before the secured party disposes of the collateral or enters into a contract for its disposition, or before the debtor's obligation has been discharged through retention of the collateral, either the debtor or another secured party can exercise their right of redemption. So what does that mean? Either the debtor or the other secured party can pay the entire debt along with the secured party who repossessed the collateral's reasonable expenses. So you pay the expenses and the debt, you can retain or get the collateral returned. When the debtor pays the full debt, the secured party must complete a termination statement, which is a document indicating that it no longer claims a security interest in the collateral. Where does this go? This has to be filed every place it filed a financing statement, and it must be done within a month from the date the debt was paid in full. So the secured party has to give notice that it no longer has that secured interest. So that financing statement that it filed, everywhere it filed, they also need to file a termination statement.